She was unreasonable when she saw the door ajar. A reasonable person would have went a safe distance away and called the police. It was unreasonable to enter potentially finding an intruder, shooting and killing someone. Guilty, guilty, guilty. This is one of those issues that's, prosecutors have almost gone there to a certain extent, Chris, and I want to ask you about this. There have been times where prosecutors have said she had other options, that she could have taken cover. To me, that is dangerously close to saying she had a duty to retreat. How does all this play in Texas, and how does it play in this case? Is it unreasonable to actually enter as opposed to taking the reasonable thing, which would be run away and call police?
Well, when that came out, Amber Guyger was on the stand and Jason Hermas was questioning her. Couldn't you have done these things? Didn't you abandon your training by going in? Didn't you have a radio? So he went through a litany of questions, and I thought that was probably the best part of his his cross-examination of Amber Guyger. However, they doubled down on it in closing argument, and the problem with that is when they do come dangerously close to saying there's a duty to retreat or she should have retreated, but then that's followed up by the judge reading the jury's or the court's charge to them, and it's specifically saying there is no duty to retreat. So we know that the jury is going to look at the charge, they're going to read over the charge, and I think that the government runs the chance of losing a little bit of credibility when they spend a lot of time on this duty to retreat, and then the judge tells them there is no duty to retreat.
Yeah, I thought it was kind of dangerous because they were doing it throughout the entire trial, and then, you know, the defense looks like, hey, we're the ones following the law here, and they're not. Quick question on that. Is it possible that the jury can believe that it's unreasonable to even enter once you know there's danger? That she had some sort of unreasonable reaction of entering the apartment, which she thought was her own?
Well, that may not be what the law says. I think, and you know, I hate to divide it on lines of gender here, but I think if you have women sitting on that jury, imagining putting themselves in that scenario, that they are walking into what they believe to be their apartment, even if they are armed, okay, even if they regularly carry a gun, and they see a man of any size get up and make a move towards them, the first thing that they're doing is backing up and maybe running down the hallway or shouting for somebody. It's not firing into the apartment. That may not be the law, but I think you're going to have to get over that hurdle with female jurors.
Oh, could I disagree there?
Sure.
As a female, she is a female police officer, and I agree that, but remember, she opened the door, maybe in her own mind, I left it open this morning. I've been working for 13 and a half hours. And when you see somebody in there and you're a police officer and you know you're armed, you say to yourself, let me see your hands, let me see your hands. And it didn't happen. Horrible tragedy, but I don't see it as murder.
Trista, defense is not really helping her. It's not a plausible scenario. The victim was trying to figure out what's going on, and she got trigger happy. Mistake or not, she has to pay for it. This is the part I want to focus on. Mistake or not, she has to pay for it. Is that jury nullification for the prosecution?
Yes.
I don't know if I've ever heard of that before. Jury nullification for the prosecution. Mistake or not, doesn't matter. She's got to pay.
All they're thinking is a dead body. Someone lost their life due to her being trigger happy. So, of course, I think it would be the reverse role of jury nullification for the state or the prosecution in this case, just based on that
Quick,
comment.
nerdy legal question here. Is jury nullification for the prosecution a reversible error? If somehow she gets convicted and the jury says, mistake or not, we didn't care.
No,
all right.
No, I don't think
Hold on
so.
to that.
Doesn't matter.
Doesn't matter?
If she's convicted, she's
convicted.
convicted.
All right.
Yeah, depending on what type of
So I
error
know
is in the
prosecutors
trial.
aren't allowed to appeal when they lose. All right. I want to put the next, I got two comments that are very similar to each other. Begin with Jessica. I found the prosecutors way too aggressive and condescending. They could have went about it a lot better. To me, it seemed they were talking down to them, meaning the jury. If I was on the jury, it wouldn't sit well with me. Then Lisa writes, I found the initial closing argument by the prosecution to be condescending. If I was sitting in that jury box, I would feel offended, says Lisa as well. And to me, when I watched it for the first time, and again, I wasn't in the actual room, so it might play different in the room because he's feeling the reaction of the jury. But Chris, I felt like the prosecutor was angry, indignant, but at times he was seeming to point that anger straight at the jury, pointing at him, saying, you promised, and I'm going to hold you to it, as opposed to saving that anger for the woman who shot and killed the innocent man. Do you think that could be a problem for prosecutors here?
Well, listen, I know what Jason was doing, and Jason Fine, that is. Jason was a good change of pace. I think that Jason Hermas and Robert Rogers and Toby Shook to a certain extent, I mean, they were pretty even kills, so we needed that uptick of emotion. But yeah, I mean, and I think at one point Jason Fine posed a question to the jury, and he just says, that's not plausible. Use your brain. And I think it was misplaced, and I just think in the heat of the moment and in the emotion of the moment and him trying to convey an appropriate passion, it did get directed at the jury. So those that are on board with the state at that point, I think they stay on board. But those that were not on board with the state, that might have been aligned with the defense, I think you cause a bigger fracture with the tone of his argument.
Yeah, that not only have to agree with the arguments, but sometimes it helps if they really connect and like the lawyer. I mean, it shouldn't have anything to do with anything. But how do you think Casey Anthony was found not guilty? That jury afterwards said, oh, we really like that defense attorney. Man, that prosecutor, he was so arrogant. Big lesson in that case. All right, Aaron, I understand why the defense wants to throw out as many ideas for reasonable doubt as possible, but at some point, doesn't it weaken their stance if they throw in stuff that is silly? I mean, the ice cream spoon placement, really? Really, Daryl?
Well, I think that the defense has got to throw out the case in chief, throw out the best defense, and then little bitty tidbits here and there. And by the way,
do you do that? Do you ever throw like as much as possible?
That might be reasonable? Absolutely.
Okay. All right.
Get their mind off of a conviction. Get their mind on the clothing, my facial expression, body language, anything. And by the way, I think the prosecution made a mistake by not talking up to the jury or to the jury. You never talk down to the jury.
Never talk down to them.
Ever.
Yeah.